Welcome back. Detained Binance executive Tigran Gambaryan has initiated legal action against Nigeria's National Security Advisor Nuhu Ribadu and Economic Financial Crimes Commission (EFCC), alleging violations of his fundamental rights. Gambaryan, represented by lawyer Olujoke Aliyu, seeks relief before Justice Iyank Ekwo, alongside Nadeem Anjawala, Binance Africa Regional Manager, who escaped custody. Both filed separate suits against ONSA and EFCC, demanding release and passports return, citing constitutional breaches. To help us understand this, I have Dr. Iwa Salami, Associate Professor in Financial Law and Regulation, University of East London, England, United Kingdom. Thank you so much for joining me today.
Thank you for having me.
All right. I'd like to start with, what you make of the lawsuit filed by the Binance executives. Let's talk about both of them now.
So, of the lawsuit filed by Binance executives, basically it's a reaction claiming that there has been a violation of their rights because, as we know, basically what they came for was to have a meeting with the authorities in Nigeria to really deal with the issues around, some of the tax evasion allegations and the opportunity basically to have a conversation as to, how the company, potentially would seek to resolve this issue. And then, of course, whilst that was happening, they got detained, which wasn't the expectation. So the expectation that was that they were coming to have this meeting because, of course, we know that Nigeria is such a huge market for in crypto assets, particularly for Binance, which is the largest cryptocurrency exchange in the world. And so therefore Nigeria is quite an important market. And in honoring the invitation, they got detained. Now it has to be said though that although it appears that there seems to be a certain form of deception here that they were actually brought in to be detained, it's actually possible that in the meetings and interviews that they're having, there may actually come out as a new, fresh information could actually come out that actually there has been a violation or a breach that then requires or warrants that more answers needs to be provided by a business. And in this case, this seems to be what has happened, that in the conversations that were being had, it became evident that actually the Nigerian authorities felt that Binance had violated certain rules and therefore detained the officials.
All right, so as an associate professor in law and regulation, I would like to ask, looking at Nigeria's handling of this case, do you think it followed, due process, really?
So it's a quite tricky one because on the face of it, you would think that, these people came in to have a conversation with the authorities because, if they knew they were going to be detained, they would certainly wouldn't have, attended the meeting. But it is the case, though, that, if there has been allegations of misgivings or violations of, in this case now, quite severe allegations of tax violations, of course, according to Nigerian law, there is that provision there to have them detained. This isn't particularly great. It doesn't look good both for the authorities in Nigeria, nor does it look good for business moving forwards, particularly around crypto asset funds and also businesses that actually want to come in to do, to engage in whatever type of transaction they're wanting to, and particularly for foreign companies as well, and as to how their employees would be protected if they come for potentially meetings like this, or if they're actually on ground. So it's, on the face of it, I'd say it's an unfortunate situation because you have two officials coming in to have a meeting to help preserve the huge markets that they have in the country, and then they ended up being detained. Anybody hearing that would obviously feel, oh my goodness, this cannot be right. But then if you look at if you kind of take a back seat to see what's going on, tax evasion is a big deal in every country, and particularly for a country like Nigeria, whose economy is going through quite a bit of pain, and particularly around the role that the authorities believe that crypto asset exchanges, such as Binance, are playing, and the impact they have on the naira itself. So there have been, a few months, I'd say a month or so back, there have been these issues around the impact of the outflow of foreign exchange through crypto assets exchanges, the big ones, and Binance being an example here, one of the big ones here, and therefore the impact that has on the naira, and is a big one for authorities to worry about. And so these, if you like, if you kind of contextualize things, this is the environment under which this action has been taken by the regulatory authority. And like I say, tax evasion is a big issue across the world. And if these are allegations that have been tabled before, Binance, then it's something that really needs to be looked at. And again, this is the unfortunate thing that happens with crypto assets, the crypto asset business. It's a global one, which then means that if crypto asset exchanges are, have to deal in countries where we have citizens transacting huge numbers, particularly huge numbers in a country like Nigeria, transacting on exchanges, then of course there would be an interest to ensure that tax provisions are actually implemented or are complied with. I beg your pardon. And in this case, there are allegations that have been tabled, and Binance really haven't been able to answer, hence this action being brought against them.
But Professor, talking about tax evasion, I mean, that's a big one if we are to talk about it. But then remember that the SEC had already issued, this particular circular saying that Binance was not trading legally in Nigeria and that it wasn't being, what's the word, regulated and all of that. So I'm wondering, this is an institution, or let's say a company that is not being regulated. This is a company that is, operating illegally in the country, and that this same company is allowed to trade for so long. And at first, why did Nigeria even allow Binance to trade or to continue whatever it was doing for so long before, beginning to take some action? And then now you're also talking about, tax evasion. I want us to understand, to help us understand these two really. When you talk about tax evasion for a company that is operating illegally.
Okay, so that's a very good question. And the issues around the regulation of crypto assets, have been a quite hairy one, because when cryptocurrency exchanges began to operate, a few good years ago, there were no regulatory arrangements or framework for them. There wasn't any requirements for crypto exchanges to comply with the most basic regulatory requirements, such as to know the people that are transacting on them, such as what we commonly refer to as KYC, know your customer requirements. So all the exchanges across the world were operating, and the nature of cryptocurrency exchanges is that they're not your traditional brick and mortar, exchanges. These are exchanges that really are facilitated and really operate and run on blockchains, and therefore, it's very possible that you could have exchanges operating, and because it's very global, very possible that you would have individuals that are interested in engaging in crypto asset exchanges or cryptocurrency exchanges, buying and transacting on those exchanges. And originally, we had a lot of that happening across the world. But as regulation became an issue, and as authorities began to find that actually these are big businesses transacting globally across the world, and of course, across the world, and then also obviously allegations around money laundering and terrorism financing, links with cryptocurrency exchanges, it began to become obvious that there was a need to actually put regulatory framework in place. So the framework, as is the case in most of financial developments that we see, the regulation usually would come, usually comes after, and this has most certainly been the case with crypto asset exchanges. So we're kind of working our way back, not just only in Nigeria, indeed across the world, to put regulatory frameworks in place, whether that's sort of knowing the people that are transacting, KYC provisions, or indeed tax provisions or tax regulatory frameworks sort of in place as well. So the answer to your question really is that there has been a slow, if you like, a slow rollout of regulation for crypto asset exchanges, but across the world, these are actually coming to fore, and these are actually being put in place. The question really is how regulators would want to approach regulating their own dimensions or their own aspect, the way I'd say actually the transaction, the impact on them. So, for example, a few years back, we had the US IRS, Inland Revenue Service, really bring an action against Coinbase and asking, knowing that the certain of the parties that have been transacting, they were in violation of tax, and basically asking that Coinbase really let them know or give them the names of a list of certain parties that they had identified as actually violating provisions. So there are mechanisms for countries to put in place certain, if you like, provisions in place to actually get, to know what is actually going on in certain on those exchanges.
If you can hear me, Professor, I want us to narrow this down and just take it right home. I'm saying that if you're operating illegally, are you still expected to pay tax at the same time while the the regulators have identified or spotted you as an illegal entity, and at the same time you're also expected to pay tax? I just want you to help us clear up that aspect.
Okay. So there are two things here. Now, Binance, the action that was brought against the organization that claimed to be Binance Nigeria, I think last month or a few weeks ago, that was deemed as operating illegally, had no relationship with Binance, the global firm that is in question here. So just to clarify that. Now that Binance Nigeria organization or entity, Binance, the global firm, had dissociated any links with it. That entity was not registered. I beg to say that that's not the entity we're talking about here. The entity we're talking about here is Binance, the global exchange. So that entity, yes, was operating illegally, whatever it was. But the actual issue at stake here is that we've got Binance, the global exchange officials who have come for a meeting because, of course, Nigeria is a big market for them.
Okay. And who have All right. So in closing now, Professor, what potential outcomes, can be expected from the upcoming court proceedings scheduled for April 8th?
So basically, they've been arraigned. What they're going to be asked to do would be to plead. So they're given the opportunity to plead whether they're guilty or not guilty. And of course, we know that, I'd be surprised if they plead sort of guilty to this. And then after that, a trial date will be set. So this can potentially be a long drawn case that we have here. Okay. And it's hoped that it will be ironed out, because it doesn't give it's not a very good case for the industry at large, I'd say, to be honest.
All right, thank you so much, Dr. Iwasalami, for sharing your thoughts with me today on Business Edge.
Thank you for having me.
All right, there you have it. We'll take a break now. When we come back, we turn our attention to Central Bank releasing a guideline for the recapitalization of banks in Nigeria. Stay with us. The Central Bank has announced a new set of capital thresholds for Nigerian banks, requiring international, national and regional banks to maintain minimum share capital of 500 billion naira, 200 billion naira and 50 billion naira respectively. This sweeping financial reform was announced on Thursday, March 28, 2024. And joining me to unpack this is Nabila Mohammed, investment analyst, Chapel Hill, Denham. Thank you so much for joining me today, Nabila.
Thank you for having me. Good morning.
All right. Well, the CBN governor hinted about the recapitalization of banks sometime last year, although this is due to prevailing macroeconomic challenges and headwinds, whether domestic or global. However, I would love you to begin by telling us what necessitated this recapitalization at this time and what you think about the timing.
So, like you said, it was hinted last year, so the banks already had in mind that truly something was going to happen in regards to capitalization this year. So they were already pre-informed, I would say, to start with. Now, talking about the time, we understand that the banks are, very key, very vital when it comes to contributing or supporting businesses to promote economic growth. So when we have them well capitalized, they would be able to carry out their function of providing, taking money from the excess part of the society and giving it to those that would need it to encourage or improve output of businesses. So for that to happen, really, banks have to be capitalized. And when we look at the timing that this thing is coming at, the capitalization is largely going to be equity capital driven and not debt capital. So what that simply means is that given the current bullish run that we have in the equities market, the year-to-date return of around 39%, is largely in support of whatever equity capital rates that these banks will have to do eventually. So I think the timing is not bad at all, given that it's coming when we are beginning to see interest in FPIs coming in and stuff. So that would definitely encourage or bring it open to those sets of investors that want to take advantage in the equities market and also take advantage of the fact that we are in a bullish run currently. So I think the timing is not bad. And I think that given that they've already been pre-informed about it, so they were already prepared for whatever it was that the CBN was going to come out with. So.
All right, talking about, the timing and then especially the bullish run in the equities markets that you made reference to, let's look at this particular one. What do you make of the exclusion of retained interest from the calculation of banks' share capital? Saying that in accounting terms, when you talk about retained capital or retained earnings, it actually talks about what you have, but of course you're not sharing it out or you're not giving it out to shareholders as dividends, you're retaining it. I mean, it's considered a component of a company's equity because they represent profits that have not been distributed as dividends, but are instead reinvested in the bank. So what do you make of this particular provision?
So really what I make of it is that it's just clear that the CBN wants to have the banks inject fresh capital into their business and not capital from their business that they want to retain. So if we look at the two aspects of the capital that they said was going to be what makes up the new minimum capital requirement, that's the share capital and the share premium. Those two types of capital came in via fresh funds. It has nothing to do with their retained earnings. So for the bank, that's the central bank in this case, to be specific and say that they have to shore up capital looking at those two avenues, it means that they want to see fresh capital into the system and not just recycling of what they have from their retained earnings or whatever they have retained over time. They want to see fresh monies come into the system. I think that is really what they want to see, what the CBN wants.
It's nice to say some of those things, but then some of the bankers themselves who spoke under the condition of anonymity expressed the opinion that while the central bank prefers them to retain most of their earnings to reinforce their capital base, it should not concurrently, at the same time, prevent them from counting these undistributed earnings as part of their capital. What do you make of this really? If we have a situation where the people this particular regulation is made for are sort of murmuring or complaining about it, aren't you also going to look at their own argument?
So yes, the argument is valid, and when we look at it holistically, that retained earnings will definitely form part of their shareholders' fund. But for the capital of the bank, it will not be part of it. So I'm sure that the CBN would have thought about this thoroughly before they came out with this circular yesterday, that it would have to only be share capital and share premium, excluding the retained earnings. I'm sure they would have given it much thought, and they would want to see that would form definitely part of the total equity or shareholders fund of the bank. but it wouldn't be what the capital itself, the main capital base of the bank, because they would want to see the fresh funds come into the banking system in terms of capital raising. So I believe they would have thought about it before they came out with this circular. So even if they have concerns about it, they would definitely have time to meet with the CBN and trash and understand where the regulator is actually coming from with regards to the circular that has been released.
Okay, now this particular circular talks about recapitalization being aimed at bolstering the bank's resilience, solvency, and capacity to support growth in the economy. Is this being threatened right now as we speak?
So it is not necessarily being threatened if we look at it from the point of view I'm going to share with you right now. So we understand that the banks are in the business of lending, taking from the excess part of society and giving it out to those that need. That is one function that is very vital when we are looking at economic growth generally. And for them to do that, they need to have the adequate funds that they will be able to fall back on in order to grow or supply to the aspect of the economy that needs funds to boost their own productivity. So what that simply means is that when they come out to do this, their capital raising, we will definitely see influx of, especially, just look at it from an asset and allocation point of view. We will definitely see the likes of PBs that are not so exposed to equities take advantage of this particular transaction that is going to happen in the banking space. We would also see FPIs, we've already started to see them, but then those that are keenly interested in the equities market be able to take advantage of this particular transaction. So it is not being threatened. Rather, what we're seeing is, what we're going to see is that we're going to have more well-capitalized banks. We're going to have a banking system that is going to be really going to be supervised by the regulators at the end of it. So everything just boils down to the long run and the target of the $1 trillion economy. And I would say that it's not being threatened. Of course, in the short term, there might be some capital raises, rights issue, and mergers and acquisition.
All right, now that you've touched on that, Nabila, I'd like to ask you this really. They've been given three options. Talk about injection of fresh equity capital, M&As, and of course, there is that about upgrade or downgrade of license authorization. Now, what must these banks consider before settling for any of these options?
So every bank has its own strategy for expansion. That's if you're looking at it from mergers and acquisition point of view. Every bank has what it wants. They know what they want. They know how their growth trajectory, what they want their growth trajectory to be. So they would have to consider that. They will have to if they are looking at the first option or the capital raising, for instance. Let's start from that. They would look inwards and see how much they actually need to increase their share capital, their minimum capital requirements to, and now look for the best options. Remember that the circular also mentioned that for whatever plan that they decide to take, they would have to submit it to the CBN for review on or before April 30th, before they start to implement whatever plan they choose. Now, for the mergers and acquisition, for banks that have for banks that would want to take that route, they would have to look at their brand, their identity. What is it that they want? Which banks out there really is in line with what they would want to see and how they intend to see themselves within the next 5 to 10 years. So those are the things they would consider before they now take the route of, okay, let's do a merger and acquisition with a particular bank. Now, the last option, which in my personal view, is not really the best, which is to scale down your license. It would just mean that that particular bank that will take that route will want to preserve its identity and brand, and just feels like if I have the minimum requirements for a regional license, why not? If I have a minimum the requirements for a national license, why not? So these are the things that I believe they would consider before they take whatever step in that direction with regards to capitalization.
Thank you so much, Nabila Mohammed, investment analyst, Chapel Hill, Denham. Thanks for your thoughts and time.
Thank you for having me.
Manchester City and Chelsea faced potential expulsion from the Premier League if found guilty of breaching financial fair play rules. The 23-24 season has already seen two clubs receive point deductions for similar infractions, prompting scrutiny over the consistency of penalties. Legal experts outlined potential sanctions, including warnings or expulsion for Premier League clubs found in breach. Both clubs are implicated in significant breaches, with City denying 115 allegations and Chelsea flagged for illicit payment. Manchester City's case is set to conclude in the 2024-2025 season, while Chelsea awaits formal charges amid ongoing investigations. For more on this, I'm joined by Babatunde Koiki, the editor, Sports Desk, News Central TV. Thank you, Babatunde, for joining me today.
Good morning, Perpetua.
All right, so how does this severity of, alleged breaches by Chelsea and Manchester City compare to Everton's offence, which resulted in a mere 10-point deduction? Okay,
for those who don't understand, there's something called profit and sustainability rules in English football. Basically, if you every club must not record a loss of more than £105 million for 3 consecutive seasons. Now, the likes of Manchester City and Chelsea, they've definitely gone way beyond that particular limit. And of course, because of Manchester City's ownership by, a state-funded entity, there's a lot of belief that a lot of the contracts, a lot of the income that they've declared does not fall within the regulatory parameters. Basically, they've overinflated the value of these contracts. For example, Manchester City is sponsored by Etihad Airways, and a lot of people believe that the value of those contracts are far less than what is declared on the books. This is what a lot of people call financial doping. In the last 20 years, English Premier League clubs have become increasingly attractive to investors all across the world. Now, of the 20 clubs in the Premier League, 15 of them are currently foreign-owned, 8 of them by Americans. So this has turned out to be issues regarding how these clubs are run, whether they're run sustainably, profitably. Basically, the authorities are trying to make sure that these clubs do not spend more than they earn. In the case of Chelsea, their charges relate back to when they were formerly owned by Russian oligarch Roman Abramovich, and it's understood that they received secret payments that did not reflect in the club's accounts, but thereby benefited the club, which is definitely in a breach of the PSR rules. Now, what this means is that both clubs could potentially face, it could be a sanction, it could be a warning, it could be a points deduction, or it could even go as far as even outright expulsion from the Premier League and demotion to the lower league.
All right, so besides the demotion, relegation, or what have you, what other unlimited punishments, could the Premier League consider for FFP breaches?
Well, pretty much a sanction. It might include a transfer ban. These clubs might not be allowed to sign players in order to improve their their squads, maybe for a period of time, maybe 1 season, maybe 2 seasons. It all depends on the severity of the allegations, and it has to be determined by a judicial panel. Now, it's pretty much the same thing that you have in a court, where there's a panel, there's a lawyer for the club and a lawyer for the FA, and both of them have to state their cases, as it were, in order for them to reach a ruling, reach a conclusion, whereby a ruling will determine where the severity of the infraction by each club.
All right, so how long might the legal process take for Manchester City's 115 alleged charges and, any potential charges against Chelsea?
Well, for the Manchester City case, it's actually been going on for quite a while right now. They were actually charged in February 2023. A lot of people thought that this would have actually gone to the judicial panel by now, but it's been going on underground. Manchester City have retained the services of one of the most high-profile lawyers in England, and in fact, he's even gone as far as charging the head of the panel, Sir Murray Rosen, of being an Arsenal fan, and basically he's questioning his credibility and his impartiality in this particular case. So it might take some time, but we do hear that it might be November, December before. Maybe around November, December, before when the Manchester City case is up for hearing. But for Chelsea, it's already currently being investigated now. They might receive a formal charge anytime soon.
All right, so what are the chances of Everton's appeal against their 10-point deduction? What are the chances of it being successful?
It's already been successful. They've successfully appealed. They initially received a 10-point deduction. The appeal was successful, so it's been cut to just 6 points. Now, what that means is that they still stand a very strong chance of escaping from relegation. Now, being relegated from the Premier League is a major, major blow for many of these clubs, because the Premier League is the most lucrative football league in the world. The minimum that many of these clubs can make just being in the Premier League is as much as 225 billion pounds. Now, if you take that amount of money away from your financial operations every year, it leaves a huge hole in your profit. So it helps us, Everton, in the sense that they might possibly escape relegation.
All right, well, let's look at this now. How is the independence of the panel, the particular panel that decides on FFP punishments ensured? And, can there be potential bias? Can that be a concern?
Yeah, that's exactly what Manchester City are claiming. They're claiming that the head of the panel is an Arsenal fan. So they're saying that he might not be biased. And if you've been watching the Premier League for the past 2-3 seasons, Arsenal have been title contenders alongside Manchester City, who are already being charged. Now, Arsenal were runners-up to Manchester City last season. They are currently top of the Premier League, while Manchester City is fighting to retain their title. And so Manchester City have attacked the credibility of the panel by saying that the head of the panel is basically an Arsenal fan, so his own position might be tainted, as it were. So it's been interesting seeing how everything is going on, but a lot of clarity will be revealed in the coming weeks.
Okay, so what preventive measures could the Premier League implement to ensure, stricter adherence to financial fair play regulations moving forward?
Well, I don't think they can do any much more than they're currently doing now. All of these clubs, they're having their books scrutinized every year, every season, at the end of every season. So it's pretty much a case of running a fine comb through all these accounts and making sure that there's no hint of financial doping, as it were. Because basically what the Premier League is trying to do is that these clubs do not spend more than they earn. And new relegations are coming, making it increasingly impossible for these clubs to have any form of financial issues. Basically, what the authorities are trying to do is to ensure that these clubs continue to operate as a going concern in a sustainable manner, and they don't basically rely on, the sugar daddy syndrome, whereby there's just a foreign owner who's just pumping money into the club. He's not concerned about sustainability. He just wants to buy success. So the authorities are bringing new regulations in trying to ensure that these clubs are run sustainably, and we'll be hearing about them pretty soon.
When you keep talking about ensuring that they do not spend much more than they earn, the question then would be, in whose interest is it at the end of the day? Isn't it an irony that we have to help someone do the right thing?
Yeah, you're quite right. It's quite ironic, considering the fact that if these clubs are relegated, a lot is on the line. The fans, there's a loss of pride for them. The clubs also lose a tremendous amount of money. You would think that these clubs would do the right thing. But football is such an emotive sport that the quest for buying success, sometimes common sense is thrown out of the window. We've seen these clubs owners just throw tremendous amounts of money into buying the biggest players, signing the biggest managers, building the biggest stadiums. And it's not done in a sustainable manner, because if anything were to happen to the owner or the owning company, everything falls flat. So it really, that's why the authorities are really trying to ensure that these clubs are run as sustainably as possible, because you must remember, these are global institutions. Some of them have roots that go back as the 1800s. They are not playthings, and that is why a lot of people have very strong emotions when it comes to the ownership of clubs and how they are run, and even who owns them in the first place. There was a lot of talk in Newcastle when Saudi Arabia was going to take over that club because of human rights issues in that country. So it continues to raise a lot of questions, and hopefully these clubs will continue to get it right in order to prevent any kind of failure in the future.
So how will the final decisions on Chelsea, Manchester City, and even Everton's cases set a precedent for future FFP investigations and maybe punishments?
Okay. So the thing about precedents is, once it's done, it's basically goes into legal jurisprudence, and it will be used as a basis for whatever happens in the future. If by any chance that Manchester City or Chelsea face maybe a 30-point deduction or a relegation, it is going to change the landscape of the Premier League tremendously. Clubs will be scared, because if clubs as big as Chelsea, Manchester City, clubs who are in quotes too big to fail, face the ultimate penalty of being relegated, it will change things tremendously. Every club will sit up. Every club will not want to undergo that kind of punishment. So nobody wants to be the scapegoat. Nobody wants to be the sounding board or the testing ground for such hefty punishments. So you can imagine that Chelsea and Manchester City are doing everything that they can to argue their case But we'll be keeping an eye on it because it promised to be interesting. 115 charges, that is what Manchester City have been charged with. And the thing about financial breaches is when you're in breach of one, that might mean that you're also in breach of another one. So it's going to be very interesting to see how this pans out when the hearings begin. Well,
I know we're all waiting to see how it will pan out, but what are your own expectations?
Okay, so I'm hoping that the authorities will do their job without fail or favor because the Premier League continues to be the shining light and one of the leading sports leagues in the world. It is a competition of tremendous potential. And any failure in that structure begins to send alarm bells around global sports, not only football, in terms of financial viability, sustainability, how clubs are run, and management potential. So I'm just hoping that they do the right thing. If they have to be punished, I'm hoping the punishment will be commensurate with the crime and not overboard. Because likes of Manchester, Everton have complained that they received a 10-point deduction. For what? And if Everton is receiving a 10-point deduction for just a small charge, what could possibly happen to Manchester City, who have been charged with 115 breaches of PSR rules? So I'm just hoping that whatever happens, it happens as quickly as possible because the Manchester City case has dragged on for far too long and people really want a resolution. And I'm hoping for one as quickly as possible too.
All right, we all are. Thank you so much, Babatunde Koiki, Editor, Sports Desk, New Central TV.
Thank you.
All right, that's our offering today on Business Edge. Many thanks for watching. You can follow us on social media. We are at New Central TV. You can also go to our website, www.newcentral.africa. You can download our mobile app on Play Store and App Store. Till next time, I am Perpetua Fasami Peter. Bye for now.